Good afternoon, everyone. Thanks so much for taking the time to attend our panel discussion on lawyer ethics and discipline. My name is Humada, and I'm the head of office and a senior program manager at the American Bar Association Rule of Law Initiative, and I will be your moderator for this session. We have a fantastic panel lined up for you today. So I have here with me Ellen, Haifa, and Asil. Ellen Rosen is the Regulation and Global Initiatives Counsel of the ABA Center for Professional Responsibility. She advises its Standing Committee on Professional Regulation and regularly consults with the US and global regulators about their regulatory systems. She was counsel to the ABA Commission on Ethics 2020, which developed amendments to the ABA Model Rules of Professional Conduct and model regulatory rules to address the challenges and opportunities presented by globalization and technology. She advised the ABA Commission on the future of legal services and advises its Standing Committee on International Trade in legal services on regulatory matters. She speaks frequently at international, state, and local bars regarding ethics and professional regulation. She chairs the International Bar Association's Bar Issues Commission Regulation Committee and is a past member of the IBA Professional Ethics Committee. She's a fellow of the American Bar Foundation. She is the immediate past president of the Chicago Council of Lawyers and continues serving on its executive committee and board. Before joining the ABA, Ellen was the senior litigation counsel for the Attorney Registration and Disciplinary Commission of the Supreme Court of Illinois. She received her JD with honors from the Indiana University School of Law. Next up, I have Aishat Haifa, who is a senior attorney at Shah Hussain & Co. Lawyers, LLP. She has over 15 years of experience as a practitioner. Her area of expertise is banking and finance, acquisitions and investments in the Maldives. She is a seasoned litigator and has successfully represented clients on complex contractual and tax disputes at Maldivian tribunals and courts, setting important precedents. She has also represented clients at international arbitration forums such as International Chamber of Commerce and Singapore International Arbitration Center. She has served in various posts at the Maldives Monetary Authority over a period of 8 years, including as a deputy counsel prior to setting up as a private practitioner. She has a Bachelor of Laws with honors from the University of London. She is a member of the Chartered Institute of Arbitrators and is listed on the Maldives International Arbitration Center's secondary list of arbitrators. She is the current chairperson of the Ethics Committee at the Maldives Bar Council. Next up, I have Muhammad Asil Hassan. Asil is the legal counsel to the Ministry of Foreign Affairs of the Republic of Maldives and has previously worked as a senior state attorney at the Attorney General's Office and at the Permanent Mission of the Maldives to the United Nations in New York. He has represented clients in cross-border arbitration, including at the Singapore International Arbitration Center. Asil is a member of the Double Taxation Avoidance Committee, the Continental Shelf Committee of the Republic of Maldives, and he is also a board member of the Foreign Service Institute of Maldives. He is also a founder member and board member of the Public Interest Law Center in Maldives, which is a non-profit organization run by lawyers that offers legal services pro bono on matters of public interest. Asil has completed professional programs and trainings in alternative dispute resolution, including a program on negotiation by Insight Collaborative at the New York University School of Law, and he has attended classes on environmental law and policy at Columbia Law School. Asil is also a climate change fellow of the Alliance of Small Island States, AOSIS. He read law at Oxford Brookes University and has a master's degree in international and commercial dispute resolution law with a special focus on arbitration from the University of Westminster in the UK. He was the youngest elected member of the first Executive Committee of the Maldives Bar Council, established under the Legal Profession Act of 2019. Asil has been registered as a lawyer in the Maldives since 2013. So as you can see, we've got a fantastic panel lined up for you here today. And the panel discussion will be on fostering efficiency on the lawyer disciplinary process. First, Ellen will present on evaluating system efficiency in ethics processes from an international perspective, while Haifa will talk about efficiency in the ethics process from the Maldivian context. Asil is up last and will talk about the lessons learned and implementation from the perspective of a former executive committee member of the Bar Council. Each panelist will have 15 minutes to make remarks. And after the panel discussion, there will be a Q&A session for approximately 45 minutes. Ellen, the floor is yours.
Thank you. So can we cue a slide for me, please? Got it. So talking about efficiency in the discipline system, when you heard me speak a little bit earlier, I mentioned to you that there is not a one-size-fits-all solution, and the same is true when you're looking at increasing the efficiency in your disciplinary system. As we lawyers are always fond of answering a question, well, it depends. So things are going to change constantly. I mentioned before, you're going to have to make some adjustments. And underlying all of this is the objectives of discipline. So when you're looking to do your enforcement and your caseload processing, you always want to keep these what we call regulatory objectives or goals in mind. And so on this slide, what you see are the components that, in my experience, impact system efficiency and effectiveness. And as I go through these, what I'm going to do is talk a little bit about where I see the Maldives system fitting in right now and touch on some additional opportunities for the system as it matures. And one critical thing to remember when we talk about efficiency in caseload processing, doing it promptly is important, but speed is not the primary goal. Your disciplinary investigations and prosecutions need to proceed promptly, but not in a way that sacrifices thoroughness and fairness and due process. And your Rule 12 of your disciplinary rules actually speaks to this. So, structure. It's not just your processes and your resources and your personnel, et cetera, that can impact the efficiency of a system. The structure of your system can also contribute to inefficiencies. And your structure here is not complex. It flows logically. It flows in a sensible way. But one area where the structure of your disciplinary system can impact efficiency is through the use in your disciplinary rules and in the LPA of volunteers, members of the BCM, instead of a professional disciplinary council to investigate complaints. And this is not to say that other jurisdictions don't use volunteers to do that. They do. There are several jurisdictions in the United States that still use volunteers to investigate complaints, but they do that in companionship with a professional disciplinary council. And so in my experience looking at disciplinary systems, using a professional disciplinary council to investigate and prosecute cases tends to be much more efficient. Why? Well, it's simply because as volunteer lawyers, you don't necessarily have the time or the resources to investigate complaints in the same manner as a paid staff person, a paid professional. It's not a negative reflection on your work. It's not a negative reflection on all the time and effort that you put in as a volunteer. It's just the facts of life. You have your obligations to your clients and to your practices and to your other activities. And especially in smaller jurisdictions like the Maldives, you have a greater likelihood arising of conflicts of interest between the volunteer lawyer, investigator, and prosecutor and the respondent. And that can lead to the need for recusal and the need to find an alternative volunteer to investigate, and that can take time. So that also is an efficiency issue. So resources, certainly sufficient resources are going to be necessary in order for any system to operate efficiently. I'm not just talking about funding or money, but human resources and technology. Disciplinary cases, regardless of where they're happening, are becoming much more complex everywhere, and especially in cases, again, involving funds and involving technology. So having good technology to allow you to effectively investigate those cases is important. I talked a little bit about that in my other presentation. And that's the other reason why it's important for a system to routinely go through what is a real needs assessment. You know, should, for example, at some point in the future, the Maldives system think about having a professional disciplinary council to conduct those investigations, or at least provide enhanced assistance to your ethics committee panels. That might require enhanced funding. Also, Your caseload size is not necessarily indicative of a need for fewer resources. As I mentioned, cases are becoming more complicated. So a small caseload with a large percentage of highly complex matters is going to require more time. It's going to require more resources. And what might be considered a small caseload is not so small for a system that's under-resourced. There's a lot of different methods by which jurisdictions and countries screen complaints. That's at the very front end of the system when you are looking to determine whether or not, in this case, the Bar Council has the jurisdiction to investigate. Does it fall under Rule 54 or not? And so having in place an effective and quick process for that early screening of complaints is really the first piece in the puzzle of having an efficient caseload processing. Cases that don't fall within the jurisdiction of the Bar Council or do not allege, if true, they don't allege a violation of your ethics code, should be really quickly addressed and removed from the system so that your executive committee can then focus more on making decisions as to whether or not to investigate other complaints. In the United States, thank you. In the United States, we call this a central intake system. Most of them call it either triage or screening. And often it happens within a matter of days to no more than 2 weeks, but it's quick. And this, again, is where the use of a professional disciplinary counsel can come in very handy in terms of helping that screening go very quickly. Another global commonality is that the majority of complaints made against lawyers are about instances of lesser misconduct or things that might indicate bad office practice or the need for some help. So technically they may be a violation of the rules, but a single instance or a few instances of non-serious misconduct, such as lack of communication, I think the question arose is, have I committed misconduct if I don't call a client back? You know, if you want to read the rule that way, but you have to look at the spirit of the rules too. And so if I were a disciplinary prosecutor and I received a complaint, for example, that lawyer A did not call client B back once, or twice, I probably would not go ahead and prosecute that case. But what it might be indicative of is that something else is happening and maybe the lawyer needs some help. And so I talked about these alternatives to discipline cases, which helps you get the case out of the system, so you're not devoting resources to investigating things you don't need to investigate, but you're getting that lawyer some help. And that's also, again, like a second piece of that puzzle of caseload efficiency. Let's see. The other piece of this remedial function of the diversion cases is it provides the bar, in this case the Bar Council, an ability to deliver enhanced member services, because what you're going to need to do is create some programs to actually help the lawyers, a law practice management program. You may develop a course on bank account management, business accounts, and accounts where you must hold client funds. And what studies have shown is actually that these programs can be very, very successful. Recidivism rates are actually very, very low. So again, something to consider for the future. So time standards. Often where we say in the United States the rubber meets the road is you're going to have time standards and you're going to abide by them or you're not going to abide by them. It's just really not quite that simple when you're looking at investigating and prosecuting and adjudicating cases of lawyer misconduct, because it's really not just as simple, well, don't lie, don't cheat, don't steal. Things like conflicts of interest, matters involving money can be very complicated and they can take a longer period of time. But the efficient completion of investigations is one of fairness, as I mentioned before, to respondents and to complainants, and it's critical to public trust and confidence in the system. There's a lot of factors that impact how quickly a case is going to move through the system, and having these case guidelines, I like to call them guidelines instead of time standards, and I'll explain why in a moment. They're not the end-all, be-all to efficiency, but they do provide you that framework to operate, and so setting appropriate ones for each stage in the system is important to do. Some of those are already built into your rules, I think it's Rule 7D of your disciplinary rules provide that the Bar Council has to provide a complainant its decision whether to investigate within 14 days. I believe that is the screening component, so that is consistent with global practice. Rule 13 provides that the Ethics Committee panel charged with investigating a matter is supposed to develop a timeline for the investigation, which I think is a really good provision to have, and that the Secretariat is then responsible for panel adherence to that timeline, not a job I would want. Respondents are given 10 days in which to initially respond to the complaint, and then 20 to submit a closing statement. There doesn't seem to be a time period that I saw for the Executive Committee to rule on the final report of the Ethics Committee. So again, you have some of this already built into your rules. In my experience, the development of internal metrics, not just those that might be in your rule, is going to be helpful to a system. And I think the important piece about this, because I said this earlier, nobody is going to meet every metric all the time. It's just not possible. It's not realistic. But you want to set realistic expectations for how quickly the case is going to move through the process. And that is why the failure to abide by a time guideline or by a guideline that's a standard that's set forth in a rule should not be directory. So if you don't abide by that timeline, it doesn't mean the case gets dismissed. It's not like a statute of limitations or a period of limitations. Really, to me, in my experience, having looked at dozens and dozens and dozens of systems, they're a means by which you're going to gauge the efficiency of the system, but it also helps you identify systemic problems, and it helps you develop solutions so that if you have a place in the system where things are getting clogged up and they're not moving, you're able to identify it and figure out a way to help it move forward. So these have to be developed with appropriate flexibility. Again, because of the varying nature and complexity of complaints, not all cases are going to be the same. You may have one lawyer that has multiple files. We like to call them frequent flyers. You may have ancillary litigation. You may have a very document-intensive manner. And so you need to build into things, into your time guidelines, things that are also not going to be in your control. You may have a respondent who is recalcitrant and is not responding. There may be various reasons for not responding. Some of them may be intentional, and some of them may be what we like to call the ostrich syndrome, which is it's really scary to get a disciplinary complaint. I have gotten one in my career. I even, I worked for the system. I understand it. I didn't like seeing that envelope arrive in the mail. It's very anxiety producing. So sometimes people just figure, it's causing me stress, it's causing me anxiety. If I stick my head in the sand, it'll just go away. It never does. You're usually going to be making it worse. But this isn't necessarily in the control of the system, and so it also impacts caseload efficiency, and it's something that you have to take into consideration when you're building these time metrics. My recommendation would be that most of these be internal and not rules-based. A lack of rules-based time standards and having them internally, it doesn't mean your system is any less strong or any less effective in meeting the mission of protecting the public. I just think the internal guidelines allow for more flexibility and discretion in determining whether or how a matter might need more resources or need to take more time. And this, I think, brings to mind the rule I mentioned earlier, which is your rules provide that the ethics panel has to develop a timeline for its investigation. And I think inherent in that is that flexibility and that discretion to treat cases according to their facts and circumstances. Some jurisdictions will actually prioritize cases for purpose of time guidelines by categories. Is it a high-risk, low-complexity case, a high-risk, high-complexity case, high-risk, low-complexity, low-risk, high-complexity? So these also help you kind of build out those metrics. And I had mentioned earlier sanction standards. So just like time metrics, it's equally important for the prompt, fair, and consistent imposition of disciplinary sanctions during the adjudicative process. If you have that framework, it helps your adjudicators know what they're doing, what they're supposed to be looking for, how they're going to judge the case, how they are going to develop their report and recommendations. And so not only is it an issue of consistency, it's also an issue of efficiency. So it's going to also help those who are responsible for investigating the cases and for lawyers who are defending other lawyers before the system to understand that a certain type of discipline will likely yield a certain type of sanction. So it helps everybody all around figure out how to best allocate their resources in terms of time. So the ABA has standards for imposing lawyer sanctions. That framework includes considerations such as the nature of the duty that is violated as a violation relating to representation of a client, violation of the duty to the legal system, the profession, of the public. What's the lawyer's mental state? Was the misconduct knowing, intentional, negligent, or reckless? What is the injury, actual injury or potential injury from the misconduct, and the presumptive sanction? And then once you get to the presumptive sanction, you can look at factors of mitigation and aggravation. For example, has the lawyer been disciplined before? That would be considered an aggravating factor by way of example. And so another example is the Bar Tribunals and Adjudicative Service of the Bar Standards Board in England and Wales has developed a sanctions framework for barristers that's very similar to the ABA guidance. They also look at, what is the misconduct that has taken place? What is its seriousness? Where does it fall on that scale? What is the harm? They determine that initial sanction level for the proved misconduct, and then they apply aggravating and mitigating factors. And so, again, this is developed not only for consistency in sanctions, but to help with the efficient processing of cases. And last, but certainly not least, training. Training is incredibly important, especially as you're starting off in a system. Right now, you don't have a precedent bank, if you will. You don't have disciplinary precedent, so you're going to have to look somewhere. There's plenty of places to look. You can look to the ABA. We have our annotated sanction standards. It gives you an idea in the United States as to what happens. Plenty of information available on various regulators' websites. But it's going to be important for you to start establishing your own precedent and developing your own frameworks for your own cases that are unique to your jurisdiction. But training is going to help not only to ensure consistency, it's going to help ensure the expeditious resolution of disciplinary matters. It's going to help keep your staff and your volunteer current on changes in the law, current on changes that you're going to be seeing that are going to impact lawyer behavior, whether it is mental illness or substance use or other types of physical incapacities. These are all things that are happening globally more and more. Stress and anxiety on lawyers, some of it driven certainly by your practices every day, but COVID didn't help. And all of these impact lawyer conduct. And so if you have a case where there is misconduct, you're looking for factors that might be causing it, and they might be mitigating. So training needs to also include education about the process itself and about the rules. So all of these things, they need to be mandatory, in my view. I would recommend certainly that training take place for your newer members shortly after their appointment, and you can develop different types of training. We have a guide to training lawyer discipline system volunteers at the ABA that I'm going to be providing information to the Bar Council about. But it's just very, very important because the practice of law is changing rapidly. A lot of that is driven by technology. And it's important also that these materials, these training materials, be made available to all the members, preferably in electronic format, and that they be available electronically. And so the last thing I would say, and I hope this has come through in the remarks, is flexibility is important and adaptability is important because things are going to change. Nothing is going to be written in stone. Change is constant. And so the system has to be able to reassess and adapt as necessary. And with that, I might have hit my timeline. I'm going to pass things over to Haifa.
Thank you, Ellen.
Hello again, it's Haifa. I wanted to talk a little bit about the ethics processes that we have in place right now. I think that's quite relevant to this conversation that we're having today. I've put together some slides. Is it on? They're putting it on now. Okay. Throughout the day, we've heard, speakers talk about, how new this system is that we have in place. As you know, the LPA came into force in October 2019, and the disciplinary standards and the legal practice code of conduct was issued about 2 years after, in September 2021. Having said that, the ethics committee was set up in April, around April 2020, and it's been active since. The point that I'm trying to make through these comments is to say that there was a gap between the time the LPA came into force with some broad general principles that you're supposed to apply to your everyday practice, and detailed standards that were issued giving guidance on how to conduct yourselves in your professional life. I'm sure most of you would already know what the Ethics Committee is. It's a statutory standing committee that was appointed by the EXCO of the Bar Council, and it's a 9-member committee according to the regulation that's in force right now, but we have 8 members currently active on the committee. An important point to highlight is that all are voluntary members. Our entire disciplinary system is built around a volunteer ethics committee who is charged with the responsibility to investigate complaints against lawyers. The ethics committee does have a mandate to advise the EXCO on the code of conduct and amendments to be made. However, the main mandate is to investigate complaints received on lawyers. So what happens is a 3-member panel is appointed by the EXCO whenever a complaint is accepted by the EXCO. I will very quickly give an outline or rattle through the investigative procedure that we follow, that the ethics panels follow. Immediately upon appointment, as Ellen mentioned, we are required to meet, convene, and set up a timeline on how this investigation would go. We would immediately notify the respondent lawyer and provide a copy of the complaint and request to respond. And the panel is empowered by the law to summon persons, documents required for the investigation. So the panels would immediately convene and take a look at the documents that are received and make a decision on, what information from whom and how soon, or and go through with that. The regulation that we have right now requires that we provide an opportunity for respondent lawyers to appear and to respond. So we do schedule an investigative hearing in front of the panel, where the panel would once again request respondent lawyers to provide their defense and make inquiries as required. There's a detailed process that's outlined in the regulation that these panels have to follow. So we have to make sure that these opportunities are provided, even though some of these things might be repetitive, and we may not even, collect a lot of information in between the first time you're given an opportunity to respond and by the time or after collection of information. So despite that, we still have to go through the motions, and we have to give them copies of everything that is collected and give a final opportunity to respond. And the role of these panels are to make a determination based on facts that are collected on whether or not a complaint can be sustained, and making a recommendation to the EXCO on the sanctions that is to be taken. On an average, it takes about 10 to 11 months the moment for panels to complete their investigations. This takes me nicely into the next slide, which is to talk about the challenges that we encounter at the ethics committee and panel levels in carrying out this work. It's an important piece in the disciplinary process, the work that these members in the ethics committee that they do. The main issue that I find is that these panels, the work it revolves around the availability of members. So even though, we put together a nice timeline, we say we want to meet 3 weeks from now or 4 weeks from now, it's sometimes just not possible to go through with those timelines because some of the members might not be available, there might be hearings, they might be stuck in court. So it happens more often than not. So we end up canceling or rescheduling these meetings and the timelines would, shift. Similarly, we do encounter situations where respondent lawyers are not cooperative or responsive to requests by the panels. They might not respond, they might ask for more time, they might not show up for a hearing, and this process would go on for a few weeks, even months in certain cases, because we do try very much to get the respondent lawyer to say something in their defense, because it's always better to hear the other side of the story, and it helps with the investigation to understand what has happened. So that some of the delays are caused because of the non-cooperativeness of the lawyers. Something that Ellen touched on was the fact that this is a fairly new system, and these are volunteers. And the fact that everybody on the ethics committee had to learn on the job. Not just the ethics committee, but members of the secretariat who provided the support, they all had to learn on the job. We didn't have templates, or we didn't have written down systems. We just had a regulation. The regulation said that you have to provide responses in 5 days, you have to do a timeline, you have to summon people. Templates of the summons were not available, templates of reports were not available. We didn't receive any training on how to do these investigative reports. I mean, a lot of these members do come from rich backgrounds where they have carried out investigations, maybe in their line of work. They might have worked in courts, they might have been members in tribunals. So they do bring in vast experience, but they don't have the necessary experience that is required to implement a disciplinary system for lawyers. So that was something that did create a lot of challenges for the committees. And initially, it took a lot of time to just do the learning. The other matter that we encountered was initially all of this work that I just mentioned had to be carried out by the members of the ethics committee. And the secretarial support that were provided was minimal. For example, letters that were to be sent to lawyers, we might have some support from the secretariat in drafting these letters, but ultimately writing the report itself was something that the members had to carry out themselves. And we found that that was a cumbersome task, and that itself took a lot of time. But this is something, that has improved significantly since. We do have better support from the Secretariat now. We do have drafting support. We do have legal counsel support from the Secretariat, and that has sped up the process significantly. But it is something to be noted that the Bar Council itself is under-resourced, I suppose, because it has a large mandate. It carries out a lot of work, and I understand that the staff that provide the support to us are also providing support on other matters. So we're just using the same people for everything. So that is a fact that we all have to accept, and that does cause delays. The system itself is new. The sense I got from today was that everybody is here to learn about the new system, how it works, and that is something that has to continue, because what we found is some might not be as aware of the LPA as others, and on the interpretations or the applicability, so or the code of conduct itself. So I think the lack of awareness of the codes of conduct is something that we found to be challenging as well. I think as we go along, with awareness sessions, training sessions can be improved. And the final point that I wanted to talk about was on sanctions, and the fact that we don't, at the moment, have guidance on commensurate actions. What do we do, how do we determine, how do we make a recommendation on sanctions to be taken against a lawyer where we find, that the complaint is sustainable. So, I mean, I understand there's something in the works right now, but the fact that there's no visibility across panels, so across the ethics committee on the types of complaints and the types of sanctions that are applied or recommended, does again create challenges, delays. I think something that we could think about or consider would be sort of a knowledge base or information sharing mechanism where ethics committee or members of the ethics committee are made aware of the types of offenses or commensurate sanctions. I mean, an offense and sanctions matrix might be something that's helpful for the ethics committee and members of the panels. Next slide, please. The final matters that I wanted to talk about relates to the topic of this panel, which is raising or increasing, improving efficiency of the ethics systems. I think a lot of the things that I say probably would also be repetitive and reflective of what Ellen has said as well. I think the most important thing would be education and training of the bar itself, the members of the bar itself, as well as the members of the ethics committee and other committees that are involved in the disciplinary process. I think that, you know, we would also be more efficient if we were to increase secretarial support, administrative support, or expand the role of the secretariat in supporting the ethics committee and the panels in carrying out investigations and in implementing the disciplinary system. Again, something that we might want to consider down the line would be, do we need to increase the numbers of people in the ethics committee if we were to receive more complaints? And if the existing members are unable to cope with multiple cases, we may want to, at some point, consider that as well. Because it ties in with the fact that we do not want these disciplinary matters to be prolonged, because everybody, even the law requires that these matters are dealt with on a speedy manner and quickly, because nobody wants this hanging over their heads, quite, you know, anxiety-inducing. So I think it's unfair on members on lawyers or respondent lawyers to have these matters prolonged for months and months. I think 10 months, 11 months is just too long. We may also want to look at the ethics regulation, as we are now 3 years, you know, into the process. We would have, you know, experience in implementing it. We would have made notes on what works, what doesn't work. I mean, it's something that we could look at. And the final thing that I wanted to talk about was the sanctions regulation, which I understand is in the process, but, you know, it's still not in place. So I guess when it comes into force, this will again improve the efficiency of the disciplinary system. That's all I have for now. Thank you. Over to you, Asil.
Good afternoon, everybody. I've benefited a lot from the remarks by Haifa and Ellen. I will try to contribute to the conversation. In 2019, when we were elected to the very first executive committee, I remember we had the very first meeting, perhaps the day after we were elected to the EXCO. The members who were elected at the time we had a look at the LPA, and we decided that each member would sort of take on responsibility of overseeing particular areas under the LPA, licensing, legal education, etc., etc., etc. I had the privilege of volunteering with Justice Shujun, who was a former executive committee member, to work on ethics. 3.5, almost 4 years later, it has been a very interesting, enlightening, and at the same time challenging experience working on contributing in however small way it may have been to develop the ethics regime. Now, after Wisham and the fantastic EXCO was recently elected, I thought that my role would end there, but the common denominator seems to be Secretary General Jabin, who has yet again found a way to make sure I'm speaking here at this panel. Thank you for that. So I will try to sort of briefly share experiences that I have gained and what we've learned through basically trying to implement the LPA within the past 3.5 years. So as you know, the Legal Profession Act, it sort of introduced the first codified ethics code for lawyers to have to adhere to in the Maldives. What it did was, and this is my view of it, it challenged age-old ways of doing business in the country, age-old ways of doing business for lawyers in the country. And what that means is, well, of course, it came with notions such as professionalism, integrity, as Ellen has said a couple of times, don't lie, don't steal. And these aren't things that you need to be taught. These aren't things that necessarily need to be written down in a law or codified. Those are things that are, you know, I would say should be inbuilt in any society. So even at the absence of an codified ethics code in the LPA, I would say that these were the guiding principles by which lawyers were conducting themselves. But at the absence of a disciplinary mechanism, the question is, how do you hold lawyers accountable? Of course, apart from contempt of court procedures that may take place. So I look at this from the perspective of the Maldivian society. There's a very popular theory that goes that we are all separated by 6 degrees of separation. I would submit that that is significantly smaller in the Maldives, significantly lesser degree of separation in the Maldives. If you look across this room, I'm sure you'd be able to find friends with which you go to play football, friends with which you sing karaoke, relatives, spouses, distant cousins. That is the reality of the community that we live in. It is a small, close-knit society. And with that comes certain intricacies that are, and from my experience, I can tell that it is very similar to other smaller island societies or smaller island communities, such as the Maldives. We have a habit of very openly and very comfortably discussing clients, cases. You would vehemently argue with your opposing counsel in a courtroom, and then later that night you may find yourself again with the same counsel in a badminton court or a tennis court, and they're your very good friends. And then you naturally have this habit of, you know, having comfortably discussing facts of cases or clients, or saying that they're my client, they're doing this and this. So what I'm trying to say is that these are things that are, you know, cultural intricacies that were carried on into our professional practice. So what the ethics code does is, what it told us as lawyers is, you have to maintain confidentiality. You have to, you know, sign NDAs where required. You have to work in the best interest of your client. And also that you have to be professional in dealing with opposing counsel, dealing with other people in the profession, and also dealing with the clients of the opposing side. So the fact that LPA 2019 came with an ethics code, and later on the ethics regulation that was developed under the code that promulgates all of this, means that you have to take a step back and look at how you were conducting yourself in the profession, because there's a very strong likelihood of you being potentially in breach of ethics, the ethics code. So that was sort of the position in which we started from, and I think even now, and if I use the phrase teething issues, I think is what we are experiencing even coming into 4 years after the LPA has come into effect. So apart from this, the very obvious challenges that we faced, or rather the EXCO faced when we started work in 2019, I would say, is the delays in our setup. We had difficulties in securing office space. We had difficulties in securing the finances required to completely and independently and fully implement the LPA to the extent that was envisioned under the law. And these delays, of course, naturally translated into delays in the ethics processes. It translated into delays in acquiring the capacity required and supporting, as Haifa said, supporting the ethics committee by providing the necessary secretarial staff that they're required, the equipment that they're required, and in all other means as well. As you would know, the Bar Council benefits from the volunteer support and volunteer work of its members in every aspect. And most illustratively, I think I would say ethics is one area in which we can see that we have a lot of people who are willing to assist. And I don't think that is, we should not only count on volunteer assistance when it comes to such an intricate matter or such a delicate matter as ethics. We need to be able to find, acquire, and dedicate the financing and capacity required to ensure that the mechanism is run to its fullest extent. So these delays in the setup, these delays in effectively giving life to the processes that are envisioned in the LPA naturally meant that there were delays in deciding at times composing the three-member ethics panels, and other times in getting responses adequately from the ethics panel, and finally, delivering decisions at the EXCO's level. I would also like to look at expectations. I think when the LPA came into force, it came with the expectation that this is going to solve a lot of problems overnight. And perhaps that is the expectation with any law, that it would solve a lot of issues that the law specifically seeks to address. But it was very much a learning process, and I would say it is still a learning process, which is why we have been talking about, and we are still talking about, amending the LPA. We learn from the experiences that we have, and then we give feedback and suggestions on how to improve it. And as such, we have made some recommendations on how to improve the LPA as well. So the expectation from the profession, I would say, was that the LPA would raise the bar, quite literally, and that it would guarantee the involvement of all members of the bar, that it would raise the dignity of the bar. And I think the expectation also was that since the LPA has come into force, pending whatever time limits that are set up in the LPA, you would see a bar council that should essentially look like it's been there for a long time. And this is certainly the expectation from my experience. But at the same time, and I'll try to bring this in the context of efficiency, ethics efficiency. At the same time, we were struggling with trying to meet the various requirements under the LPA. Some were time-bound, some were very sensitive matters, some were matters that couldn't wait for too long. You're also required to work on reading the curricula. You have to immediately start issuing licenses, higher rights of audiences. So the ethics mechanism sort of sat somewhere in between doing all of this work as well. And taking a step back and talking about expectations again, there were times in which we saw that there was a tendency to file or bring ethics complaints against clients, ethics complaints against opposing counsel. If you're unhappy, if your client or if your client feels like the certain result that you got in a case is the result of the opposing counsel acting in a certain way. And sometimes you see cases where you lose a particular case and your own client thinks it's because of your conduct that you lost the case, and therefore it constitutes some kind of an ethics violation because they didn't do X, Y, or Z. But expectations have to be looked at from the perspective of what actually are the facts and what aren't the facts. So there could be a case where you would think that a person or a lawyer acting in a particular way is a clear breach or a clear ethical violation. But you have to look at it from the light of what the ethics code says, what the regulation says, and decide whether or not that actually does constitute an ethics violation. A lawyer acting in a particular way, a lawyer being rude or unpleasant or not using the highermost Divehi form as we have learned today, may not necessarily be an ethics violation. So this ties into being aware of what the law actually says. In his keynote address earlier today, Dr. Munawar said that the Attorney General drafts the law, takes it to the judiciary, takes it to the Parliament. The Parliament passes the law, and then you find that people are indifferent about the law, or people are aren't, giving effect to the law. People aren't following the law. And that stems, I believe, partly from not knowing what the law says or not knowing what the regulations made under a particular law says. And for many reasons, I believe, there were cases certainly seen from the reactions that we saw on some media, some newspapers, social media posts, and voiced out by private lawyers that it made us take a step back and wonder whether they have actually read the law. Because there were some very clear provisions in the law. For example, when you look at Article 54 on submitting disciplinary complaints, it talks about what kind of a disciplinary complaint can be submitted to the Bar Council. And the test in Article 54 basically decides what kind of an issue the Bar Council can look into, who has the standing to submit a dispute. But the expectation was that anything that a lawyer does, whether in their private capacity or whether in their public capacity, anything at all, would come under the purview or the mandate of the Bar Council, which is not the case. And this is hard for a lot of people to come to terms with, and I believe a lot of criticism that continues to be levied against the Bar Council may stem from this fundamental flawed premise. So you have to consider what the Bar Council or the Executive Committee of the Bar Council is actually mandated to do, what they are empowered to do. I know that there's a provision in the LPA that says 39E, which says, and these are loose translation of it, that a lawyer is not to do any act that may hinder the public trust placed on lawyers and those working in the legal profession. So singularly, you are responsible for the collective dignity or good name of the entire profession, of all other lawyers and also those working in the legal profession. So if you, for example, you're rude to somebody on the road, or if you conduct yourself in a way that is demeaning, or in a way that the society doesn't view that you should act, does that mean an ethics complaint can be brought against you for being rude or for not being a very pleasant person? And again, we have to read all of that, in my view, under the test in Article 54 of the LPA, which says if a lawyer violates the code of conduct in providing legal services, number one, to a client, any party who is directly affected by the violation can submit a complaint to the Bar Council. So if you read 39E and 54 together, does that mean that everybody is any party directly affected by the violation? Is the entire society as a whole directly affected by the violation? I mean, I would not go so far as to define it that broadly. But these were the kind of questions that were posed to us. And as far as expectations go, as I mentioned before, the expectation from the public, and I think from a lot of members of the bar also, was that the Bar Council should be able to have a say or decide or initiate ethics disciplinary proceedings with regard to anything that a lawyer does, because they're a lawyer, whether they're in the courtroom or whether they're dealing with clients or whether they're out playing football or out fishing or whatever. So just to try to wrap up my thoughts, it has been a learning process, and I believe it still continues to be a learning process. And conferences like this would most definitely help to contribute to the conversation. When we first started work on establishing the disciplinary proceedings regulation and later on the ethics regulation, we had a few consultative meetings with the general public where we received a lot of interesting suggestions which were taken on board. And I believe conferences like this and the conversations that we have today will give us more content that can be used to effectively, for the effective betterment of the entire bar, because as the saying goes, no man is an island, so no one person is an expert in all matters. So with that, I would like to thank the President of the Bar, Wisham, for the opportunity to contribute to the conversation, and I look forward to the question and answer session. Thank you.
Thanks to our panelists for their presentations. Before opening up for questions, I wanted to go over a couple of ground rules. Before asking your question, please introduce yourself and let us know who the question is addressed to. And please try to stick to 1 or 2 questions so that others will also have the opportunity to ask the question that they want to. And lastly, please try to ask questions that are relevant to the discussion, which is fostering efficiency in the lawyer disciplinary process. The floor is now open for questions. I don't see any hands up. I've been told that if there are no questions for the panelists, they might ask. Oh, there is.
शुक्रिया अरवण के अली इब्राहिम अरवण वकील कम में साना दौड़ वाला लिपन इतिहास सादा है मैं दोनों का अरवण प्रैक्टिस करूँ मैं दें मिहारो अरवण सवाल आमास कॉलम बैठने वाले एथिक्स कमेटी के चेयर आया अरवण सवाल है कि इफ़ारिक हिंगाफ़िन न मुआमलाते वकील हिंगाफ़िन न मुआमलाते गतेरेगे हिंगाफ़िन न कामे एक ही पार्ट एथिक्स हुशारायें एक ही दुअस वर्ग हिंगे तोए एकमंग एबतोए उसूले कंडेलिफा सिंगल मुआमलाते हिमेने शकुआता वकी पीरियड मुआमलाते गोतुगा हिंगा बलानी मज्जेने कम मिहिंग अरवण में सवाल में खोरा सबब की मुआमलाते तेरेगे हिमेने खुद एक कंतत एक पीरियड तक हिंगा कम वेजा वकील वरग गिन दुहो एकमुन नोवील हुन्ना जेने एहम विमा मिकमंग एबतोए गोते कंडेल
शुक्रिया इंगे तो सवाल मिहारो मसल लाइक एथिक्स आगुले मसल तम्मे हुशेलनी असिल दे में दाले गोता मी सेक्शन 54 गा मियोना दे मी रूल नुनी दे मिंगन कुरी हम वन्या एकमकी वकील का हवाल कुरे वे मासिक का गुले कंप्लेंट न करना शकवा का वांच है ने देवन कमकी कमा गुले सीधा गोतुम वेस कमा गुले फरात को मुशाला शकवा का वांच है ने शकवा की फरात को मुशाला शकवा का वानमा अरुणुगे अमिल्ला विष्णुमकी मींगे तरुण बाकी बा काउंसिल के फरातुन दन्नवा वाकेनो एक में शकवा की फरात को मुशाला शकवा बचिया एगा मुआमला तक गुले कम का वानमा हुरिहा कम हिमेने मान एकम को शकवा की एकमा गुले मी से मल्टीपल फरात तक एक तेरे हिमेले कम का वानमा फहरुगा हेन्नु वेदान ए शकवा एकको इफ़रातुम हुशाला इरुगा इफ़रातुम हुशानाला कम बन्या बाकी शकवा गोतुका बेलवेगेन दानी दें कुरिन गोते कंडेलिफे कम वानमा एकमा एड्रेस कुरे दानकमा अरुंड गबुल कुरंग एन्न मेसेकी मेवा गोतुकुए मी स्लोकी मसल बेलमा बेहे गवादु एक कमेन्नो जब दे जता
इतुरो हम एवस बेफ्रे विसुआले बेतो Don't be shy, like we have great people on this panel, and Ellen, do you want to ask them a question? If not, I have a question for Haifa actually. So Haifa, as we're approaching 3 years into the launch of the LPA, what do you see as the biggest challenge to implementation of the disciplinary process?
Thank you, Humada. That's an interesting question. I think I did talk a little bit about this when I talked about the challenges that we encounter. I think the biggest challenge right now is the delays that are caused by the fact that this entire process revolves around voluntary lawyers and their availability. So my opinion is if, these volunteers were available, easily available, then, we can cut down the time that it takes to complete a matter, maybe by, say, even half. So the biggest problem that we have right now is that, there are certain, it's legislated to an extent where, for example, the respondent lawyer has to respond within 5 days from, receiving a notice from the panel investigating the matter, or 20 days, to submit a closing statement, but it doesn't legislate the other times that are embedded within the process. So it can be addressed in multiple ways. I mean, the answer is not including 2-day windows to respond, but including reasonable periods depending on the complexity of a matter. Panel should be flexible and willing to give opportunities where, you know, a respondent lawyer requests for time. But we also should factor in that, you know, sometimes it's just really difficult to stick to agreed timelines because of so many uncertainties, so many variables, that moving pieces that has to come together. So I would say the biggest problem is resources, primarily the availability of the volunteers. Thank you.
Thanks, Haifa. So since you mentioned that one of the biggest challenges to efficiency is having volunteer lawyers on the ethics committee, Ellen, could you please speak to us about how the BCM could possibly address this?
Yeah, so there's a number of ways, and obviously staffing resources are implicated. I think, you know, one way is to handle that triage system at the beginning, and my understanding is, and somebody can correct me if I'm wrong, is that there is assistance at that initial intake level by the general counsel to help do the screening at that front end for the executive committee before they refer matters to the ethics panels. You know, the other thing that can be considered is there the resources available to provide some additional assistance in terms of investigation from the staff level. It's not clear to me whether the LPA would permit that or whether that's contemplated given the duties that I'm recalling were set forth in the LPA for the Secretariat. But as there is an opportunity, as always, to amend rules, that may be something worth considering, or certainly considering, as many jurisdictions do have, a professional disciplinary counsel, or at least the ability to contract out with an investigator to assist. A lot of times when you have smaller jurisdictions, for example, in the United States, they don't have the funds to have a full-time investigator on staff, but they're actually able to contract out and get some investigatory help. The other piece is access to records. So, for example, court records. In some jurisdictions, it's very difficult to get court records or copies of court records. In other jurisdictions, it's easier. Part of this is, I think, a bench bar relations issue, is that, you know, for example, we had a relationship with our courts, and so when a disciplinary investigation was ongoing and we needed a court file, we were able to get that file without additional delay. And so sometimes it's a matter of talking to who might be the sources of some of the information you're seeking, whether it's the courts, the clerks of courts, understanding, meeting with your banks, and having them understand that, you know, the role of the BCM and what it is charged with doing by law, and that also may also help facilitate the speed with which certain records are obtained.
Thanks, Ellen. Asil, since you spoke about managing expectations and realities, how do you think what Ellen just spoke about would work in the Maldivian context?
Thank you for the question. First off, let me say that, as I have mentioned before, I think there's a lot to learn in the entire process for us. When establishing the ethics code, we drew inspiration from the ABA code, of course, and also the regulations set up under the International Bar Association. So there are a lot of concepts and ideas that we have imported from the ABA and the IBA, which we continue to do so. Ellen and I were at the International Legal Ethics Conference about 4 weeks ago, 4.5, 5 weeks ago. And that was a very enlightening experience in which I learned two things. One, there are other nascent bars in other countries that are trying to do exactly what we're trying to do. And they're facing very similar issues and very similar problems to what we are facing. with regards to capacity constraints, and also with regards to introducing an entirely new regime into their respective societies. And number two, that all other bars are constantly learning as well. They're picking up ideas and established practices from other jurisdictions and bringing that on board so that they are able to effectively create the most efficient or a most efficient system as possible. So in that context, I think we have to face the reality of the capacity constraints that we have and possible financial restrictions even going into the future. And therefore, we have to figure out ways in which we can work around these constraints, even whether it is by utilizing the existing potential of volunteer lawyers, paralegals, or other volunteers from within the bar. So in that regard, I think it's useful for us to have a reality check on where we are, what we have, and what we wish to achieve.
Thanks, Cecile. Do we have any questions from here? I think.
Hi, my name is Ifa. My question is that I understand that the members of the ethics committee currently are voluntary. So what are I think that the main challenge that is faced is the availability of the members. So what are some of the reasons why we don't make it a remunerated position? Is it just the financial capacity, or is there any other ethical or other reason why we do not make it a remunerated position?
Who would you like to address your question to?
I'll try to answer the question from the experience that we had it certainly was to start off a financial constraint. Absolutely it was. And number two, there were a lot of other important areas to which we had to focus, to which we had to get experts and get work started as soon as possible. And therefore, it was difficult to make a compelling enough argument to direct the finances that we had to remunerate members of the statutory subcommittees. But it was very evident even from the very start that in order to do this in a meaningful way, because you have to value the time of senior lawyers who are coming in and giving their time to a voluntary process, you have to value that, you have to respect that, and I absolutely respect every single member of all the subcommittees who are able to give their time to come and effectively give their time to a process with which at some days they don't even walk away with a thank you. So in order to establish this in a meaningful way and to get the job done properly, I think it is very important that members of the statutory subcommittees are effectively remunerated for their time. So that's the answer for that question. And one of the advantages of no longer being a member of the executive committee is that I get to ask these questions too now. So I'm on the side that's throwing stones, which I did tell Wisham earlier as well, so I definitely echo the concerns.
May I ask the American comparative perspective, because we had the same discussion as in the US, the discussion on remunerating subcommittee members, exco members, and this enlightened.
Yeah, we don't. I'm not aware of a jurisdiction that does, other than to reimburse expenses, for example, travel and food, that reimburses their volunteers. Some of it is optics. It is also, the perception of a conflict of interest. And so there is that issue as well. And it's typically solved, certainly in the United States and other jurisdictions, in terms of having an actual compensated separate disciplinary council to do that work and to have the volunteers in a bit of a different role. So I was just consulting in a jurisdiction where they actually do use disciplinary volunteers to help investigate or to investigate. and it's the culture of that jurisdiction. And they're very wedded to it. But when you talk about the same issues come up, but it's interesting because when you talk about, well, would it be different if we compensated you, you still have that full-time job, right? You still have your clients to attend to, et cetera. So I don't know that the compensation solves the underlying resource problem, the timing problem. But it was interesting that the reaction was from the volunteers was very negative, which I found interesting. But there are things that you can do. There are certain jurisdictions, for example, that allow their volunteers to have CPD credits for the work, and certainly to recognize that contribution in other ways. Yeah, and I think that's where, for example, the CPD credit may come in. In addition, some jurisdictions have required pro bono hours. And so, for example, you can have credit towards your required pro bono hours through your volunteer work for the disciplinary systems. So, for example, in Illinois, I'm not required to do pro bono, but I'm required to report to the regulator my pro bono. And my volunteer bar work counts towards that. So.
Thank you. Oh, we have one more question.
Sorry, just one last one. I'm sorry, keeping it. So just to sort of assist with efficacy, I suppose, from our end of the line, you know, being the lawyers whom clients will be complaining about, are there themes or common complaints that you're seeing, and are there sort of things that we could tweak in our practice that could completely avoid that? You know, for instance, it might be a less use of Twitter. I don't know, but you know, anything that you might suggest that might help lessen the caseload that you might have. That question is for Haifa, if you may, please. Thank you.
Thank you for the question. I think the General Counsel might be more in a better position to answer the question because it's got the statistics. There are common themes that we do see. I mean, we don't get hundreds of cases, to be very honest. How many did we get this year? Maybe 12? 12, yeah. So we're looking at a very, very small number of cases here. So it's difficult to say if there's a common theme, or we're looking at different kinds of things. So for example, we received multiple complaints about lawyers representing clients who have not appointed them, for example. So that's one. The other one is the lawyer was taking way too much time to complete a matter, and that was a complaint. And we received complaints about lawyers making remarks in public places, in meetings, you know, regarding the judiciary, for example. So, I mean, there's no one type of cases that we're receiving, but I think what might help as a preventative measure would be the education and the training. I think the more we know about what's expected from lawyers, what the standards are that lawyers should abide by, we can avoid these issues. I think I would recommend that everybody, you know, read the code of conduct closely and see, you know, whether there are questionable things or whether there are gray areas, you know, where you might be in breach or you potentially could be in breach. So I think my answer would be to educate ourselves on the code. This is fairly new code, as Asil mentioned. You know, this has changed the way we've done things for many, many years, and it might be, you know, a cultural change because a lot of us in practice for many years didn't have standards to live by. So the fact that we now have detailed guidance and the fact that, you know, we spend time learning and we spend time educating ourselves on what is expected of us, I think would act as a preventative measure and might even be a deterrent and reduce the number of complaints that are filed at the Bar Council. Thank you.
Do we have any other questions? We have one question from over there.
Hi, just because we're talking about efficiency here, would you say the three-member panel, the requirement under the LPA to have a three-member panel, is that a challenge in itself because of the nature of some complaints might not be too complex? Or do you think because of the nature of the complaint, because it's ethics related, it's important to have at least three members?
Who would you like to address it to? Haifa?
And maybe we could get a comparative view on international best practice as well.
Thank you, Mansha, for the question. I personally, again, a personal opinion, I personally think that, the three-member panels are important because, first and foremost, we're a self-regulated body, so even the disciplinary process is made by lawyers, for lawyers, and implemented by lawyers. And the opinion of three is always, better to get a balanced view, especially if the three people, bring three different perspectives. So I think it creates a balance that is in favor of a respondent lawyer. So I personally think that a three-member panel is important. Asil, do you want to add to this?
And yes, I agree with what the Chair Haifa has just mentioned. And the ethics subcommittee is different from other subcommittees in its constitution because of the requirement to have a three-member ad hoc committee to preside over each ethics complaint. And there are advantages and challenges to that as well. I'll focus on the challenges. The challenges is that you need to have a large enough pool in this ethics statutory subcommittee to ensure that you are able to effectively constitute a three-member panel every time. A three-member panel that clears all the conflict checks, because sometimes you have cases where there are successive cases in which, for various reasons of conflict, members of the panel are not able to be represented in the three-member ad hoc panel. A larger ethics subcommittee would certainly help more efficiently set up the three-member panel by clearing all the ethics violations. But the part about the three comes from the LPA. That's what we have for now.
And interestingly, comparatively, three seems to be a magic number. Where there are volunteers used, it's often panels of three. I don't know why that is. I think if you get any larger than that too, while it's important to have a diversity of views and a diversity of experience, when you start to get larger than that, you have, as they like to say, too many cooks in the kitchen, and it's harder to get to a decision point. But in terms of, kind of comparatively, most often what you actually see are the volunteers acting in an adjudicative role, which would be the role of your executive committee or your appeals committee. And there too, it tends to be in numbers, groups of three. So it does seem to align.
Thanks, everyone. Unfortunately, that's all the time that we have for today. Ellen will still be around, as I'm sure will be Haifa, and Asil might be around as well, so they might be happy to answer your questions afterwards. I'm really sorry. Thank you, everyone, for taking the time to attend our panel discussion. I know it's been the end of a long day. Thanks.